Hi, Robert Wareham again from the Law Center, continuing our series on House Bill 19-1177 pertaining to extreme risk protection orders, otherwise known as the red flag bill. In our prior segments, we talked about who has standing to bring a petition for an extreme risk protection order, the process that will take place once a petition is brought forward, the evidence the court is to consider, and then what the court's options are when conducting the hearing that is required to be held within 14 days, as well as renewal of subsequent orders. What I want to touch on in this is sort of a miscellaneous provisions of the Act. First of all, when surrendering firearms, I think it's probably safe to assume that initially these firearms will be turned over to the law enforcement agency that is serving the extreme risk protection order on the respondent. But one of the provisions allows the respondent to opt for selling or transferring possession of the firearms to a federally licensed firearms dealer so that they can be stored or that they can be potentially placed on consignment for sale. If they opt not to do that, however, then it does place an obligation on local law enforcement to store the firearm. Now, we know that many of the counties, the vast majority of counties in Colorado, through their county commissioners, have indicated that they are not going to appropriate or allocate any funds to create storage facilities and things like this. Stop and think about it. This could become a significant burden for law enforcement to store multiple firearms. I mean, I know people who own dozens and dozens of firearms that would take up quite a bit of room. There is a provision that certain firearms can be transferred and stored by family members, but that's limited to antique firearms, curio or relic firearms, as those are defined in federal rules and regulations. So that's the only time when you can transfer it to a relative. There is a provision that if someone else comes forth and alleges, well, those firearms don't belong to the respondent, those firearms belong to me, then law enforcement, it essentially says it empowers law enforcement to determine whether it's a valid claim, which seems a little curious to me. It seems like it should be a judicial officer that makes that determination. But then those firearms can be turned over to the rightful owner, but it's with an agreement that they will be kept out of reach or they'll be secured away from the person who is the subject to the extreme risk protection order. There is also a requirement, and I suppose it's a situation where somebody gets served with the extreme risk protection order, but law enforcement doesn't immediately exercise a search warrant. Perhaps this is one brought by a household member or something like that. They are basically given 24 hours in which to surrender their weapons, either to law enforcement or to an FFL that can take possession of them, provide a receipt, and then they are required within 72 hours, the respondent, to file with the court certification that they have complied with the order. If that does not come in, then law enforcement is allowed essentially to notify the court that it's apparent that the respondent is not complying with the court orders, at which point law enforcement can seek a search warrant to go in and seize the weapons. And here's the actual language on a person other than respondent claims title. It says, if a person other than a respondent claims title to any firearm surrendered or taken custody of pursuant to section 16.3.301.5, then he or she is determined by the law enforcement agency to be the lawful owner of the firearm. The firearm shall be returned to him or her if the firearm is removed from the respondent's custody and control or possession, and the lawful owner agrees to store the firearm so that the respondent does not have access to or control of the firearm, and the firearm is not otherwise unlawfully possessed by the lawful owner. I have had people come up to me and say, what happens if my adult son is living at home and they issue an ERPO against him? Does that deprive me of my right to possess firearms? Well, I suppose you could argue, no, it doesn't, but it puts some limitations on that right, because you are essentially made responsible for assuring that the respondent in the extreme risk protection order matter does not have access to that to that firearm. If a person fails to relinquish their firearms, then it could be found that probable cause exists for the issuance of a warrant, and it is at that point that the first criminal charges basically come into play. Possession of firearms by a person who is subject to an extreme risk protection order is guilty of a Class 2 misdemeanor if they failed to relinquish their firearms after being personally served with the ERPO. Now, what happens when all of the ERPOs go away, either by expiration or by filing, or by dismissal? If an extreme risk protection order, a temporary extreme risk protection order, is terminated or expires without renewal, a law enforcement agency holding a firearm that has been surrendered, or a federally licensed firearms dealer with custody and control of a firearm, or a relative with custody of one of those curios, must return the firearm requested by a respondent within 3 days, only after confirming through criminal history record check performed pursuant to section 2433.5, 424, that the respondent is otherwise currently eligible to own or possess a firearm. What they're really saying there is, before an FFL or a law enforcement agency can take and return firearms that they've been holding pursuant to an extreme risk protection order, they need to run basically another CBI instant check on the respondent in the ERPO case to make sure that they don't have a further disability to possessing a firearm. And then there's a provision in here that if a law enforcement agency who is storing firearms for someone holds onto them for 1 year and they are not claimed, and that's 1 year after termination or expiration of the extreme risk protection order, then they are allowed to dispose of those firearms in accordance with their own department policies. And that could include, in some departments, destruction. In other departments, the weapons are used for training or sold. So it's basically based on the policy zone department. And then another miscellaneous provision, anytime an extreme risk protection order is issued, the clerk of courts is to cause the extreme risk protection order to be recorded in the database of statewide protection orders, and in turn CBI, the Colorado Bureau of Investigation, makes sure that that is uploaded to the NCIC federal database, so that this is going to stay with the person even if they were to move out of state and know about it. The last thing I want to talk about is liability. There was an amendment floating around that I saw that created some civil liability, but that didn't make it into the final bill. I don't know where in the legislative process it got lost. So I'm going to read you exactly what the liability paragraph says. It says, except as provided in section 1314.5, 111, Article 14.5 does not impose criminal or civil liability on any person or entity for acts or omissions made in good faith related to obtaining an extreme risk protection order or a temporary extreme risk protection order, including but not limited to reporting, declining to report, investigating, declining to investigate, filing or declining to file a petition pursuant to this Article 14.5. It creates a whole new article within Title 13 dealing with ERPOs. So in essence, what they're saying there, if someone goes to a law enforcement agency and says, hey, I think this person's crazy, I want you to get an ERPO and take their guns, and that law enforcement agency, like so many sheriffs have said they're going to do, says, no, I don't want to have anything to do with it. it does create some immunity there. And then on paragraph 2, a person who files a malicious or false petition for temporary extreme risk protection order or an extreme risk protection order may be subject to criminal prosecution for those acts. So again, you would have to prove malicious or false petition being filed by the petitioner. A very high standard to prove. And I can tell you, in over 20 years of doing domestic relations work and handling lots of temporary and permanent civil protection orders, even without the ERPO, these were false accusations brought against people. I have never in my career seen a single prosecution for someone making a false claim. And so in my mind, that is almost a meaningless provision in there. And again, my review of the final version signed by the governor, there is no language creating any civil liability against a person who maliciously or fraudulently brings a petition for a extreme risk protection order, which is just unfathomable that someone could do this maliciously, and you could have to spend tens of thousands of dollars proving that you are of sound mental mind and you don't pose a significant risk, and incur all of those expenses and have no way of recouping those expenses. So that concludes our series on House Bill 19-1177. If you have any questions regarding this, I'd be happy to try and answer them. You can send them to my email at info, I-N-F-O, at thelawcenterpc.com. That's info at thelawcenterpc.com. I'm Robert Wareham. Have a great day.